right, guys, so we're on to our last set of notes. This one's and it will be relatively short. So remembering, I'm pretty sure I've said this before, but being that I don't talk to my virtual kids a lot, I just want to reiterate how you get your grade for notes is I take all these note videos and whatever score you get on them, I add them up and then divide by however many there were to get the average. So if you are consistently making 40s on these because you're not listening, that will reflect in your note grade. It's not just doing the video or not. I do take the grade into consideration, just like how in class, if kids turn in their fill-in notes, but they only filled in half of it, well, then they get a 50. Okay. So moving forward, not this week, because I didn't say this before, but in the future, I'm having an issue with students obviously not listening to these note videos, and students in class not taking notes like, oh, it's just a day. Or just like it's just one daily grade. So I am going to bump it up to 2 daily grades. I was going to make it a test grade, but I realized that because of the way they changed the grading this 6 weeks or this year, tests are actually not worth quite as much anymore. And actually daily grades are worth a lot. So it's probably going to be more impactful actually if I just count it twice. And we spend weeks on them. So they are worthy of a double grade. All right. So let's begin these notes. And if you're wondering why I'm so black, it's black out here at school, okay? So legal considerations, just a little bit more about the law of how to take this evidence, because I've mentioned this in our previous notes, that it's a very big deal to follow all the proper procedures when taking evidence, or it's not going to be usable in court. And that is kind of the only reason that we're taking this evidence at all, is to be able to use it in court. So if you do not follow the proper procedures and it gets thrown out, you've ruined your case. And that could have been your best piece of evidence. It doesn't matter. If you don't do it legally, it will be inadmissible in court. And then there's nothing you can do about it. They just don't get to use it. So not only do we have to follow chain of custody, so like we have to be very, very careful with our pieces of evidence, making sure it's signed off on, that the signature across the tape is not torn. So it's not only are we checking up on those aspects of the evidence, but we also can't remove evidence from a crime scene without being allowed to. So that's what we're talking about. This now is like the legal aspect of when I can take evidence from a crime scene. So any removal of evidence from a crime scene must be in accordance with the Fourth Amendment. Okay, so the Fourth Amendment of our Bill of Rights. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So basically, we have to prove that we had a reasonable search and a reasonable seizure. Shall not be violated, and no warrant shall issue but upon probable cause, so that we can't just issue a warrant willy-nilly. There has to be a lot of evidence kind of already pointing towards a person before someone will issue you a warrant to be allowed to go search their property. Supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So like the warrant it has to be very specific. It has to describe the place that's going to be searched and the things that I'm allowed to take. Sometimes in the warrant's wording, like I'm only allowed to search their car because maybe the only evidence we had was that they were driving to the scene. So it may not even let me in the house. They might give you access to the house, but not access to the shed in the back. Like it is very specific. And if they go into the shed in the back and, open it up and like that's where actually all the evidence was, if that's not what the warrant stated and you collected it, more than likely they're not going to let you keep the evidence, which makes it that much more complicated to do things legally. It protects us as people so that people cannot search or seize us without our permission, or without probable cause, without us having done anything wrong. So it protects the public from cops using their power incorrectly, using the law incorrectly. But it also hinders us when we can't get a warrant because we just don't have it. Even if you're fairly certain, that's the guy, you have, your gut feeling, you have certain pieces of evidence that are pointing that direction. But if the judge decides that it's not enough and doesn't sign your warrant, then it's not enough and you don't get to go in. All right. So to obtain a search warrant, when time and circumstances permit, do not investigate a scene or remove evidence without a warrant. So there are two parts to a search warrant request. The actual warrant itself, And then 2, the affidavit of the law enforcement officer, which sets forth the facts as to why the search warrant should be granted. So basically, you ask for a warrant saying what you want to search and seize. So like you're asking for the warrant itself. And then 2, the affidavit is what you are explaining as to why. Here's the facts as to why you think you should be allowed. You have probable cause. You should give me this warrant. Okay. So the seal request checkbox means that the police agency conducting the search warrant wants to keep all or any part of the search warrant affidavit from being revealed so as to protect the informant's identity. So if they have an informant telling like, this is why we think this, because our informant told us this, sometimes they will check that box. It's called the Hobbs sealing request, where we don't release on the warrant. We don't tell the person we're searching like who told us. Okay. So, cause we don't want them to get murdered, like snitches get stitches, that whole thing, is true, especially in like gang violence. So if we have an informant telling us something, the Hobbs sealing request would hopefully be put on that search warrant saying we can't tell the person that we're searching that like the informant's name. Okay. The Supreme Court has defined circumstances under which a crime scene can be searched without a warrant. So there are some times when it is okay to search something without a warrant. A warrantless search can be conducted, but it has to follow these guidelines. And basically, anytime you do take something or search something and take evidence without a warrant, you're going to have to prove it. So you're going to have to back that up to the judge, like explaining these things, like this is why you were allowed to do it. And if he doesn't agree, then it will be thrown out of court. If he does agree and he's like, yes, that was probable cause, then you'll be allowed to move forward. So it's kind of up to the judge's decision at that point. So under emergency circumstances, danger to life or limb. So let's say you hear, you were called into a scene because someone heard fighting, neighbors called because their neighbors were fighting. You go up to the scene. And then as soon as you get there, you hear gunshots. Okay, emergency situation. You're hearing gunshots being fired inside the house. You run inside the house and you see him standing over the body. He has the gun in his hand. He drops the gun down and runs. Okay, well, you were allowed to take that gun. You saw him do it. You were allowed to enter the home without permission because of the emergency circumstances. If there is immediate danger of loss of destruction of evidence. So if you know that they're about to light it on fire, like they're telling you that. They're saying like maybe you're on the phone with the person that you're trying to get to come out of the house. He's like, no, I'm going to burn it all down. Like maybe he has, I don't know, maybe he's stolen property and his stolen property's in the house and he's about to burn it. And you know that evidence will be lost. If you know for a fact that the evidence you were trying to seek is at danger of being destroyed, and you have proof of that, which would be pretty few circumstances, then you can barge in. And if you see the evidence, you can now collect it. If there is probable cause, the search of a person and their immediate property is in conjunction with a lawful arrest. Now, we've talked about probable cause before. Probable cause is pretty vague, okay? So I'm going to explain that more. I guess I'll have to go back into one of our assignments. But a probable cause from our previous unit is just saying that basically you're past reasonable suspicion, meaning you see them doing something that is suspicious. Now, it can't just be like, oh, I saw him in a black hoodie. Like, that's not suspicious enough. Okay, but something like an officer pulls you over and he smells weed in the car. Okay, so weed has that distinct smell. If he smells it in the car, that is probable cause for him to be suspicious of you, that you are doing something illegal, and he can ask you to get out of the car and search it. At that point, he is allowed to search it without your permission. And he could say that to the judge. If the judge believed him that he smelled marijuana, then he will get permission to, if he now searches your car and finds marijuana, then that evidence can be used against you. Now you can see how that little piece right here can kind of give a loophole in all directions. If they can, law enforcement can say certain things to get probable cause. Now, I'm not saying that I think they do that on a regular basis. I don't think they do. I do think they do have to prove it to the judge and has to be pretty obvious, but it is kind of a little, like it is vague of like what they can say is probable cause. They just have to see you doing something suspicious enough, and then they could stop you. And if they find something while searching, then now they can use it against you using that probable cause. and with the consent of involved parties. So if you get pulled over and they ask you to search your car, or if they knock on the door and they say, "May I come inside?" and then they walk inside and you have a joint lit right there on your ashtray. Okay, well, you let them in. You let them in the house, they see it, they can certainly take it as evidence. So if you give them consent without thinking, then you did. Sometimes where that could be a bigger issue is like if you were young. Okay, so let's say you're young and you still live with your parents, and the cops are coming to look for you. They want to search where you live, and they ask your parent if they can search your room. Well, it's their home. They pay for it. If they say, "Sure, come in, officer, search his room," and then they find evidence in your room, okay, well, your parents let them in and they own the house. So whoever owns a house would be allowed to give them consent even for other people there. All right, so that's kind of it. As you can see, there's still, it's fairly vague, but just knowing that when you go to court, the other legal team that's trying to get the person not convicted, right? So the defenders of the suspect, they're going to bring this up. Okay, they're going to bring this up to the judge. They're going to say, "I don't think they had enough probable cause," and they're going to give all their reasons as to why they didn't think they had enough probable cause. And if the judge agrees with them, then your evidence is thrown out. So that's why cops have to be, and forensic scientists, like you have to make sure, like if it's already designated as a crime scene, you're allowed to take evidence. But if this is like you get called into the scene quickly, you do have to make sure that you have enough things backing up your plea of why you think you were allowed to take the evidence. Because if they bring that up in court and the judge sides with them, important pieces can be thrown out. So something that was a big case was the O.J. Simpson case. We're probably going to do a little case study over it, so I don't want to talk a lot about it. But many people thought he was guilty. Not everyone, okay? So and he was not convicted. So I can't tell you either way. But the O.J. Simpson case was he was a famous football player. He is now famous for having been tried for the murder of his ex-wife, Nicole Brown Simpson, and her friend Ronald Goldman in 1994. So he was acquitted in criminal court after a lengthy, highly publicized trial. So it was a very big case. And kind of one of their, it has so many things that went wrong in that case that it's hard to know now if he would have been guilty, because so many pieces of evidence got thrown out. So first on the scene, police found evidence of blood and entered the Simpsons' home without a search warrant, an action permissible because the situation was an emergency. So the fact that they saw blood when they got called to the scene, that told them that, someone's hurt, they're allowed to enter. So they were allowed to do that. However, the police collected a pair of bloodstained gloves during their search, and that was fought over if that was allowed to be collected yet. Collection of evidence without proper warrants became the key argument used for Simpson's legal team. So even though I would think it would be allowed because of the prior sayings, it was an emergency, and then they saw people murdered, but it was a huge fight, and they really, really fought to have them thrown out because they were collected during their search. I'm going to save that for the article. But if forensic evidence is to be admissible in court, the highest professional standards have to be used at the scene. So if there's anything that they can prove that you just didn't completely have authorization to do that, and they fight, the lawyer is a better lawyer, and he convinces the jury, convinces the judge to throw them out, they can be thrown out. So the gloves were thrown out. I know a fingerprint and a blood mark and a shoe print. None of them were photographed correctly. So we didn't have them. We knew they were there. People said they were there, but no one photographed them correctly, and they were cleaned up before anyone could get to them. So it was a whole mess of a case, and he did get acquitted when he was the only real suspect. Now that doesn't mean he did it. Maybe he didn't. He was acquitted, but they did a terrible job as forensic scientists there. They did a terrible job as cops on the scene. It was not handled legally. It was not handled correctly. People did not follow chain of custody. A lot of the reason why the gloves got thrown out, they had windows of time where the gloves couldn't be accounted for. So all problematic in that case. All right, so we are done with notes. I will be grading it soon, so make sure you have your other note videos done.